So good afternoon, everyone. My name is Sergio Carrera. I will be moderating this session. I'm a senior fellow at the Center for European Policy Studies in Brussels, and it's my honor to take this function this afternoon to moderate the debates on how to fix the EU-US privacy quarrel, ? So we have a wonderful set of panelists. Just to introduce the topic, this panel is actually launching a new report that has been co-authored by Francisca Boehm, who will present the key findings, Balsami Smith-Selegas, who is a professor at the University of Liverpool in the UK, and myself. It's been the product of several months of work in the context of a task force, which has brought together a list of experts and colleagues who have exchanged in a number of meetings ideas and views and opinions about how to deal with this international data transfers controversy. And the work we've done is basically independent research on what do we see as the key outstanding issues still unresolved in light of the benchmarks that the Court of Justice in Luxembourg has set in various case law when it comes to the lawfulness of data transfers and the extent to which they are essentially equivalent in EU law. So you have the framing of the panel and the questions that we will tackle. I would like to start immediately giving the floor to Francisca, who will take us through the key findings of the report. And that has been a pleasure actually to cooperate with Francisca and FIS, not only in co-organizing this panel, but also in collaborating in the writing and the research of this report. Francisca.
Thank you, Sergio. I can just give it back. It was very nice and a pleasure to work with you. And maybe you might ask yourself where Kali Schröder is. She will join in 10 minutes. She has to hand over an award, so she will also join us. We are not only 3 presenters, but Kali Schröder will join us from EPIC in 10 minutes. So as Sergio said, we will present firstly the outcomes of the report we produced during the last months, and the report was carried out between December 23 and April 24. And in the end, we came to 10, let's say, key findings and 8 policy recommendations, which I will present to you using the slides. And afterwards, we will not use slides anymore, so don't be afraid of all the slides. I think it's just more comprehensible to present at least the key findings on the slides. And you can download also the report if you want under this link. Exactly. So, as Sergio already said, it was an independent assessment of, let's say, various presentations, contributions, and discussions that took place during 4 task force meetings. And we also conducted semi-structured interviews with legal EU and US experts. Thank you. Perfect. So now we are complete. Thank you for joining. And a lot of desk research as well. Perfect. Sorry, I have to turn because I can't see the slides somewhere there. Okay, first, so we have 10 key findings, and I will briefly go through this. So the first finding relates to the adequacy decision itself. It's a highly complex and very technical document with, from our point of view, some crucial gaps and missing key safeguards and challenges that could also emerge during the practical implementation of the adequacy decision, and which have to be closely monitored, therefore. The new EU Executive Order 14086, I think, or we think it's a visible effort by the US and by the Biden administration, which also includes, let's say, some safeguards on US intelligence surveillance activities, and also the use, or at least the naming of EU concepts such as proportionality. Yeah. Our key finding 3 is that although it's an effort, we don't think that it's done by that. We still have FISA 702 provisions and also the old Executive Order 12333 in place, and they are also operational in the US. So it's not that everything was changed completely. We also have still the large-scale collection of bulk data under the EU Executive Order 12333. And obtaining prior authorization by an independent authority is still not an obligatory requirement. There is no independent ex post review carried out by a court. And the report concludes also that a key unresolved question is whether the executive order or the safeguards of the executive order will actually lead to real changes in the daily administrative practices of all relevant US intelligence communities. And this will, of course, require further and independent monitoring and evaluation at regular intervals. For the key finding 4, so there are key concepts and notions used by the new executive order, which is there to, let's say, limit a bit the effects of the older executive orders. And they still remain the same, and they are, let's say, largely undefined from our point of view or used in rather unclear terms. And this concerns signal intelligence, bulk collection, temporary bulk collection, but also the legitimate objectives for bulk collection, which are formulated in, let's say, potentially a bit too far-reaching terms. I think Margot will elaborate on that a bit further. Further, we think that it's good that proportionality, for instance, is mentioned in the new executive order, but then, only the mentioning of proportionality is maybe not enough. There are still far-reaching differences in the understanding and also the practical use of this term in the EU, but also in the US legal system. And I think according to EU law, at least, if the very essence of a fundamental right is affected by a given policy, we don't have a balancing exercise or a balanced metaphor. So we don't do a balancing of interests. The Executive Order 140686 requires that the judges of the newly established Data Protection Review Court do not use any foreign sources of law when assessing and interpreting the complaints at hand. So for us, it's questionable to which extent proportionality requirements are used in the cases, at least proportionality in the EU understanding of the term before the Data Protection Review Court. And when it comes to the, let's say, justice dimension of data transfer and the redress dimension, the new executive order establishes a 2-level redress mechanism. First, we have the Civil Liberties Protection Officer, and second, a so-called Data Protection Review Court. And we conclude in our report that this procedure is one-sided and also secret in nature, not allowing complainants meaningful insight into the procedure and whether the relevant data have been deleted or rectified at any case. And the final decisions of the Data Protection Review Court, which will always give the same answer to all complainants, cannot be appealed before US courts. So while it is nominally called a court, we do not consider this Data Protection Review Court as a traditional court or an independent judicial tribunal in the, let's say, more constitutional sense of the word. According to our report, the adequacy decision needs to pass, say, a 3-step test to be essentially equivalent. So it needs to comply with the essence of the rights. It needs to pass the test of the proportionality assessment, and it must be justified by an objective of general interest, which, according to us, is not necessarily the case. We think that in some important cases, also the EU Charter provides a higher level of protection than the standards of the Council of Europe and the European Convention of Human Rights. And this applies to effective remedies under Article 47 of the Charter, and also regarding the judicial independence and impartiality of judges. Our key finding 9 relates to the fact that Article 4.2 of the Treaty of the EU does not exempt, the Court of Justice from presiding over cases concerning the legality of international data transfers in the name and in the topic of national security. and in this case also apply EU law also in national security terms. National security is so far, or has been developed as an autonomous concept in the EU and notion with a specific EU meaning and scope, and this provides a higher level of protection than the Council of Europe standards. This is also confirmed in the EU PNR opinion on the data retention case law, which partially can be applied in analogy. Our last key finding relates to this two-level redress mechanism, which we consider as not being essentially equivalent because it does not comply with effective remedies in the EU term, and the Data Protection Review Court cannot be considered as a court. You can find all more details and all the why we come to these conclusions, of course, in the report. Based on these findings, we come to 8 policy recommendations, partly directed towards the Commission, partly directed towards the EDPB. And firstly, with regard to the Commission, we think that the Commission should give more priority to comply with the role as the guarantor of the EU treaties and the enforcement and uniform application of EU law, also conducting its own assessment on adequacy and essential equivalence, including also the US. They also should comply with the material scope of the adequacy decision, which does not include geopolitical or foreign affairs considerations. Also, the policy recommendations 2 and 3 are directed towards the Commission, which, according to, at least to us, should increase transparency about the whole process of adopting an adequacy decision. They should also strengthen their internal assessment capacities through setting up a new independent monitoring mechanism. It could be a panel of independent academics, could be also a panel of anyone independent, and outputs should be made public of such assessments. Also, more periodical reviews of adequacy decisions with focus on effective remedies, onward transfers, and also the use of automated decision-making of AI, which is not addressed in the decision at all, should be monitored. The policy recommendations 4 and 5 relate to the EDPB, and of course we carefully read the European Essential Guarantees for surveillance measures, but we also were not completely satisfied with the content of that, because these guarantees mix, according to us at least, a bit EU law with the law of the Council of Europe, and this leads sometimes to standards which are lower than the standards of if you take only EU law. So if these, according to us, these European Essential Guarantees for surveillance measures should be updated and further clarified, and they should include all relevant benchmarks of the European Court of Justice, and also what qualifies as effective remedies under Article 47 and the EU PNR opinion. We see that the EDPB published a complaint form on its website to complain about these data transfers, which is very good. The wording might discourage some people because it repeats the standard answer given to all complainants received by the US, which is that the Data Protection Review Court will neither confirm nor deny whether you have been target of surveillance, nor will it confirm the specific remedy that it was applied or that was applied. So this wording might discourage individuals to enact complaints at all, which is of course not a problem of the template at all or of the complaint form. It's rather a structural and practical hurdle that cannot be overcome by just giving a simple template. The final, almost final policy recommendations are directed toward the Commission, and we consider if the Commission continues in establishing a non-legally binding guidance for member states on national security, then this guidance should fully align with the European case law of the European Court of Justice. And this should also, or the Commission should also ensure an effective and timely enforcement by EU member states, intelligence and law enforcement authorities of all these case law, and also of the EU data protection key, including also the law enforcement directive. So a more systematic monitoring of intelligence and surveillance practices of member states is also important, also to compare it a bit. And if a future EU-US e-evidence agreement is to be done, it should also fully align with the EU legal standards. So fine, I come to the end. The last slide, the last recommendation, or more or less a statement. We interviewed also a lot of US experts, and they all refer to this US gap regarding a comprehensive federal data protection law and independent federal data protection authority. And we learned that there is a proposal of the American Privacy Rights Act, so we put certain efforts or certain hope into this proposal, and we would recommend the US companies to support such a reform to have also more clarity on this transatlantic data transfer. Okay. So thank you very much for listening. These were just the outcomes of the report. You can read everything in detail here, but also in the report. Thank you.
Thank you, Franziska. So the report is available in our website. It has also been featured by Euronews yesterday, so you have a short story there presenting the key findings of the report. So to really to have a proper public outreach of our findings, and you will find all the details in the report. I will move immediately into our first discussant, Kali Schroeder from EPIC, please. Hi.
Hi, everyone. Apologies for coming late. I was a little double booked. So my opening statement is a little bit more broad, partly because I know that Margot is going into some detail on the specific elements of each of the regulations that are involved here, but partly because I think it's important to do a context setting for what this framework is coming into and the history and the cultural differences that we're running into here. Very, very broadly, US law and policy continuously emphasizes innovation and presents it as being opposed to privacy. That's just a fundamental structure that a lot of US debates follow. The difference there is that the EU typically tends to structure their discussion of privacy with the acceptance that privacy is a fundamental human right. That's enshrined into a lot of the laws and regulations here. That's historically recognized. In general, the frameworks coming together is about trying to find some sort of meeting ground or mutual meeting place between those two very different ideologies. And as we've seen with two previous frameworks, we haven't been able to hit that balance yet. I would argue that we also don't hit it here, but I'm sure that we'll get into the details of that more. There's problems with these approaches on both sides. On the US side, the idea that innovation and privacy are diametrically opposed is just not true. People are vastly creative and putting some sorts of safety limitations on where you can and can't go with innovation doesn't stifle it, it just gives it parameters. On the EU side, there is a lot of discussion about human rights and basing laws on human rights understandings, but there can be problems when it comes to enforcement, at least the speed of enforcement. And so seeing those conflicts emerge in this discussion, I think also is something that we need to note. Finally, when we're looking at this new framework from the executive order and whether it manages to thread the gaps between the US perspective, the EU perspective, and an overall recognition of privacy as a human right, I don't think this framework meets the task. I don't think, not only do I not think that it actually resolves those two conflicts, I don't think it meets the basis of fundamental European law. For a few reasons. One, I do think it's a problem that this is built on an executive order. I understand why. It's very difficult and very, very slow to get regulation passed in the US. We've seen that multiple times. We've had multiple iterations of federal privacy laws proposed, some with vast bipartisan support that has still gone nowhere. So I understand the urge to do something a little more quickly and do something that's a little more mobile. The problem with an executive order is that it's based on the executives that are currently in power, and it can be overturned by the next executive. So there's a stability issue there. This executive order carries with it a lot of requirements for agencies to set in place policies that could theoretically be structured to carry on through next administrations. But again, if the executive changes its mind there, the basis kind of falls out from under this. So that, I think, is a serious concern. I completely agree with the report and the writers of the report that there is a really serious problem when it comes to the DPRC, both in being able to establish itself as an independent court. I think fundamentally it's just not an independent court. And the lack of transparency around the entire process is a real concern. I understand that on the US side, they're saying that there are national security concerns, and that's why there has to be so much confidentiality and so many layers involved in the situation. But there are a lot of ways that you can be transparent without risking national security. And frankly, I think when you come down to it, this structure that's proposed really doesn't provide EU citizens with a meaningful way to exercise their own rights. They're essentially cut out of the process after the initial complaint. They will get whatever canned response is sent over to them, and then from then on, it's someone else representing them. They don't get to be part of that discussion. They don't get to be part of that debate. They don't get to submit their own argument or bring their own evidence there. I think that's a huge problem, and it would be in any structure, but I'm concerned that the efforts here have largely cut the person who's affected by the privacy violation out of the process of resolving that. And as a smaller note, because this is about how the GDPR is being applied and how that's working between the two countries, I think it's silly not to note that we're talking about a process that does not adequately provide for EU citizens' rights, but also is trying to build out some sort of basis to protect EU citizens' rights that is in no way extended to Americans at all. So the US is trying to build a structure to protect rights that it does not offer its own citizens, and I think that's part of why we have a problem. The US does not have a lot of federal experience in protecting its own citizens' privacy rights, so there's a lot of growing pains happening in the process of protecting Europeans' privacy rights in the US. I'll leave it there for now and turn it over to my other panelists, but that's kind of my context setting for this.
Thank you, Kali. So you are highlighting that this actually raises questions in both sides of the Atlantic as well. So not only purely from an EU law perspective, but also a US constitutional law perspective. So thank you so much for your comments. Next speaker is Georgia Escoma, Deloitte. Georgia.
Thank you very much, Sergio. First of all, many thanks for being so many in this room to hear about this Quarrel EU-US and whether this is really perception or not. Secondly, excellent news about the publication of the report. It was a difficult task, but I believe well-deserved, the publication, and the congratulations around. So I congratulate the team, the study team, the academia who worked around this report. I take the last arguments of Kelly a step forward. I will build on the assumption, it's not an assumption, it's a fact, that there is something available for business to now apply, to now use, and this is the data privacy framework. So the decision of the European Commission is there, and it will be more or less 1 year in some 1 or 2 months that we will have the first year of existence of this solution. So I will provide you a business perspective about how companies now perceive the data privacy framework. First of all, when a company comes to us, the privacy practitioners, as you see on the slide, I represent Deloitte here, business consultants or lawyers, what do they seek for us? It is some objective views that will be tailored in their case and worked with pragmatism that we will really advise, taking a pragmatic or giving a pragmatic perspective of things, and of course following a risk-based approach. So what business see on this Article 45, especially paragraph 3 of GDPR, that introduces adequacy. In the eyes of a company, an organization, public or private, whatever, adequacy must be and is considered to be an easy tool in order to be able to transfer data abroad, and especially cross-border overseas, in other even regions where we do not have even this privacy culture of Europe. When companies come to see us, the privacy practitioners, they will most of the times ask a comparison that we call many times and we use as methodology the SWOT, strengths, weaknesses, opportunities, and risks, basically, that come out of, for instance, in our case, the comparison of two basic data transfer mechanisms. It can be the adequacy, for instance, here we have the DPF, versus some other instruments, legal instruments for cross-border data transfers that are highlighted, named even in the same, in 45 article of GDPR and following 46 and the rest. And basically, most of the times they ask a comparison between nowadays the DPF, Data Privacy Framework, against binding corporate rules, against standard contractual clauses. So they are very much concentrating on these three mechanisms. I just carve out, for simplicity purposes and because rest of mechanisms are not so much scaled up widely in Europe for the moment. Of course, GDPR recognizes the codes of conduct and also approved the certification mechanisms as also cross-border data transfer mechanisms that can be used safely, but we do not see so much usage for the moment, at least at enterprise level. So coming back to my story, and I will just prompt here this as a case study, simple case study. We have the company that wants really to have these frequent data transfers occurring between the EU and the US and asks the comparison between DPF against BCR against standard contractual clauses. Most of the times, and I do not display here any specific methodology of Deloitte or any professional organization, but most of the times we concentrate our analysis, the comparison, by looking into 4 criteria. The first one is the user-friendliness and simplicity of the tool. The second is benchmarking. The third is stability. The fourth is transparency. And I explain myself of what we mean against these terms. User-friendliness and simplicity, please do not misunderstand me. It is not about how users feel that or data subjects, that the instrument is user-friendly or not. It's how companies believe that the instrument is simple enough to be able to operate and for them to make use of it, how the compliance teams, but also other business in the organization are going really to put the hands there and make something successful. So simplicity, we see it from the point of view of really having a straightforward mechanism where the cost of adoption is reasonable, and in terms of time, it will not take really a lot of effort and even excessive time to have it adopted. The second criterion is benchmarking. I mean, this is a bit subjective here, but really a very common, I would say, finding for the moment. There is nobody, non-company, that will go out to take a strategic decision, especially about international data transfers, without looking around of how the other companies are doing. And please challenge me if I'm wrong during the discussion. They will first of all ask what my competitors are doing, how much success there is already there, recognized even or seen in the instrument, plus also, if not my competitors, how we see other companies in the same industry using basically the tool, and again, sometimes in the country, so benchmarking very specific in the country. Stability, what does this mean? I think that the word speaks for itself. It is how much stable is the tool in order to rely on. In the legal jargon, we say that the tool really gives some legal certainty about a long-term stability and long-term compliance, that it can really secure long-term compliance, not only in terms of fines, that in case that there is a withdrawal, for instance, of the instrument, then this means that I will probably be fined if I cannot find another equivalent mechanism soon, but especially from the point of view of don't put me in an uncomfortable situation where I have to re-explain to my customers or my staff that another legal instrument is going to be used. We will need to amend notices. We will need to modify data privacy statements in our websites, and some probably still costs because we need to fix the problem. So stability is about having legal certainty about the tool. And finally, transparency. I left it on purpose as the very last criterion because it is about basically a very ad hoc criterion where we wanted to see that out of the tool, the confidence is built within the data subjects that the company indeed protects the data, that the company respects their fundamental rights, that it has taken the measures necessary to prevent unnecessary and inappropriate exposure of data to third parties, and especially for whatever reason the access may be needed, national security purposes, intelligence agencies having specific law enforcement purposes, whatever. But at the end, transparency is a very ad hoc criterion used especially in the comparison of the data transfer mechanisms. Now, if I can, or I stop here, depending on the time I take.
You can go.
Okay, so help me afterwards, if you want it, if we have time, with the exercise to map these 4 criteria to the DPF. So I have the conclusion myself. I would be very delighted to share it with you. But this is the next step of the exercise, if we have the time.
You have the conclusion? You can share.
Yeah, the conclusion is, okay. The conclusion to me is that regarding first and second criteria, user-friendliness, simplicity, and then benchmarking, for the first, it is a yes. We can say that the tool is quite simple, this DPF, but I can give arguments why afterwards. Benchmarking, I think that we need to score this as neutral. For the moment, it is a bit early to ask and demand statistics from bodies like the EU Commission. There will be a report issued soon about the first year of performance of the framework. So probably we'll have some numbers here, but already in the statistics, we have the number of 2,846, I think, companies who have already adhered to a DPF. At least we have this number. But let's say that here it is neutral, the answer. In terms of stability, transparency, I'm afraid that the answer is no, that for the moment it is a gray zone to what extent this DPF can indeed have, if it has indeed the attributes of the stable legal instrument for data transfers that basically data subjects want to see, but also regulators. And in terms of transparency, you heard already some arguments based on the report, the findings of the report, and from Cali. So again, debatable. We would need to discuss about whether transparency is achieved. For me, is a no again for the moment. So 2 no's, 1 yes, and 1 neutral about the benchmarking.
Thank you, Georgia. At least there is a yes somewhere along the line, so that's good news. I think in terms of stability, it follows very much along the line of legal uncertainty that we highlight as one of the key conclusions of our research. Legal uncertainty, also to clarify that one of the objectives of this investigation was precisely to facilitate legal certainty for everybody involved, companies, citizens, policymakers as well. And this is where we find, and we hope, that this kind of research can inform assessments in whatever shape or form. And then in terms of trust, that is also mentioned, you also mentioned, this is also quite often referred to in conferences and panels such as this one. In our report, we also highlight the need for merited trust, including within liberal democracies. That trust cannot be taken for granted. It's a daily practice. And a rule of law framework, of course, helps enormously at times of upholding trust, including among democracies. So just because you refer back on the element of trust, and this is something that our report highlights as fundamental. Now, the last discussant, Margot Kaminsky, University of Colorado, and also visiting at the EUI in Florence. So you have the floor.
Thank you so much. Thank you all for coming here after lunch, and good afternoon, and thank you for sticking with us to the last discussant of a panel after lunch. I'm going to talk about three things after I briefly talk about some of the most valuable components of this extremely valuable report. The three things I'm going to talk about are, one, the importance of understanding that law is not just words. I work in comparative law, and often you will see the same words transplanted from one legal system to another legal system, but you realize that when they land in that other legal system and context, the meaning of those words is entirely different in its actual practical effect. The other two things that I'm going to talk about then go to the specific context of this executive order. The first is the context of 702 and FISA and the FISA Amendments Act and the most recent reenactment or reauthorization of FISA. And then the second context, which Callie spoke to somewhat, is the broader context of US data privacy law or the lack thereof. I'm hoping to end on a somewhat optimistic, somewhat pessimistic note where I talk a little bit to some of the exciting gains in the data privacy policy areas in the states, but then also point to some places where I think there's still significant divergence between the two legal systems. So to start with the report, thank you both so much for enabling, participating, driving this. I think it's incredibly valuable. I intend to use it as a teaching and a policy resource. The two things that were most helpful for me as a US-based academic were the discussion of what it means to be an independent tribunal for purposes of the Court of Justice's analysis of Article 47 of the Charter. And the second was the extensive and thorough discussion of the court's own national security surveillance jurisprudence, especially around the data retention cases. Because those two things in combination made really clear for me what is lacking in the US ad hoc attempt to govern and fix the problems identified in Schrems 2 through an executive order only. So as I said, first point that I want to make is that law is not words. The executive order contains some very familiar words to Europeans that in context do not mean the same thing. Those words include things like necessity, balancing, proportionality, targeted. And when you see those words, as evidenced in the report, you have to understand that they're being interpreted outside of a European legal context within solely executive branch-based institutions. So if those words in a European context are supposed to trigger some sort of separation of powers accountability between an executive branch, a legislature, and a court, the executive order, which I do think was done in good faith, and it represents an improvement over what was not there before, nonetheless, by its very nature, as Callie mentioned, is unable to trigger that sort of separation of powers accountability because the court that is created is entirely an executive branch entity. For aspects of US national security surveillance, as I understand it, that are not overseen by the FISA court, the executive order does not put the FISA court in place as an authority. It leaves this executive branch only court as the final sayer in the space. And the advocates that are being appointed to represent EU persons are executive branch employees with some important and significant language talking about independence, but again, they're independent within the executive branch, not in a different branch that's able to check the executive branch's authorities. So the next thing I want to talk about, which was referenced earlier, has to do with tailoring. And the notion of bulk surveillance versus targeted surveillance. I'm not going to go into super fine detail, but I can in Q&A if you would like me to. In general, one of the things that the executive order is probably most notable for is an attempt to put a check on bulk collection and then bulk querying of EU persons' data. However, when you look through the purposes of collection and then the purposes that are stated for use of collected personal data, the purposes speak on what I consider to be a programmatic level rather than a targeted individual level. To understand this, I think you have to understand 702 in context. This is going to be like a very deep dive very quickly into the history of US national security surveillance law. So 702 of FISA was initially put in place, actually, it's now sort of become a dirty word or a dirty term in EU policy circles in particular, but it was put in place initially to check overreach by national security agencies in the United States. And what it did was establish a check with an actual court, the FISA court, to make sure that, at least in the context of US-based surveillance, that when national security agencies were conducting foreign intelligence surveillance, they had to go to the court for a probable cause warrant to show not that the person was likely to commit a crime, but that they were likely connected with a foreign person or a foreign government. That disappeared in 2008 when Congress, in the FISA Amendments Act, which I like to refer to in order to make my classes laugh as FISA, the 2008 FISA, came back and amended FISA to put in place provisions that permitted bulk surveillance and bulk intelligence collection. What did it do? It removed an individual targeting requirement and instead said you can create programmatic surveillance, right? Programmatic surveillance towards foreign intelligence ends without requiring showing that an individual person is in fact an agent of a foreign government. That was in response to the revelation that the then Bush administration had been in fact conducting bulk surveillance, including of US persons' communications. So that amendment happens in 2008. It gets challenged in front of the Supreme Court in Clapper versus Amnesty International. The Supreme Court doesn't get to the merits of the case because what it finds is that it doesn't know enough about national security surveillance to be able to find that the parties that were coming in front of the court have standing to pursue a claim. So here I'm not even talking about EU persons' ability to access a court. I'm talking about US persons' ability to access a court in order to have national security accountability between the two branches of government, the executive branch and the judiciary. So in Clapper versus Amnesty International, the court finds no standing because we don't know that such programs exist. Famously, 2013, Edward Snowden leaks all this information that now has been the basis of Schrems 1, Schrems 2. And we find that even though the programs exist, there are still standing obstacles to getting them into court and national security deference by the judiciary to the executive branch in this space. So 702, in my view, has since 2008 always been about some sort of, let's call it programmatic as opposed to universal surveillance, but some sort of universal or programmatic surveillance, not targeted surveillance of individuals overseen by a prior judiciary authorization. So turning to the more recent debate about 702, I think is very elucidating in understanding differences between the two legal contexts. 702 was just reauthorized in a very heated, very last-minute move by Congress. And one of the things that did not happen should raise intense flags for European legal communities who are concerned about the protection of fundamental rights. The House passed a provision that would have changed 702 to require judicial authorization via a warrant, a probable cause warrant, for any FBI queries of collected information that was not done for a national security purpose. That tells us, the fact that that didn't ultimately pass tells us, as we already know from news reporting, that 702 in its current iteration is used by the FBI and other law intelligence organizations in the United States to query collected information for non-national security purposes for US persons without a warrant. Okay, so it's programmatic surveillance. When you look at the list, I'm going to pull this up just for a second, that's in the current executive order of the potential purposes for collection. It includes things like legitimate purpose is for understanding or assessing transnational threats that impact global security, for protecting against espionage, for protecting against threats from the development, possession, or proliferation of weapons of mass destruction, for protecting against threats to the personnel of the United States or its allies or partners. All of these are about intelligence programs, not about individual concerns about individual people. All right, so coming back to my last contextual point, in order to keep us within time, I want to talk about the current context of the US lack of federal data privacy law and how it actually closely impacts this conversation. So, as Callie said, the US does not have federal data privacy law. We can talk about the recently proposed American Privacy Rights Act as the latest in a series, an iteration of various proposed federal laws. And we can also talk a little bit about state laws, including in my own dear home state of Colorado, which is frequently overlooked for looking at California instead. So table those. But the current state of affairs is that there's no data minimization in the private sector context on a federal level in the United States. That means that you've all heard of Clearview AI. You remember the Clearview AI story? So you have a company that decides that it's going to create a database of biometrics of Americans, or really anybody, from what it considers to be publicly available information, largely shared on social network sites, but also across basically the entire internet. They train their biometric system, their facial recognition system, on that data with no minimization, because it's not required legally by law in the United States on the federal level. And then they lease out this facial recognition system to law enforcement agencies around the country, which then use it to try to target individuals. So what kind of governance is there of this in the United States? There is the Illinois law, the BIPA, Biometrics Protection Act, under which the ACLU was able to claw back Clearview's ability to operate in one state in the United States. And there is the Federal Trade Commission, which governs consumer protection, which had a recent facial recognition consent decree with Rite Aid, which was really less, again, about collection of information or sharing of information, and was more about discriminatory use of such systems against people of color in Rite Aid stores who were unfairly targeted using a faulty system. So there's no minimization on a commercial level. That means that the idea that you would not conduct bulk surveillance of commercially available, personally identifiable information is not even in our private sector law, let alone our national security surveillance law. All right, last thing that I'm going to close with, because this is my other very closely adjacent area of interest, and because this year is CPDP.ai, I wanted to draw a connection to the different executive order, 14.110 of 2023, which is the executive order on artificial intelligence, in which there is a section on, I don't know what page it is, but there's a section on national security and AI. And so I'm just going to read it as my closing. It says, directing the development of a national security memorandum to develop a coordinated executive branch approach to managing AI security risks, the Assistant to the President for National Security Affairs and the Assistant to the President and Deputy Chief of Staff for Policy shall oversee an interagency process, yada, yada, that will develop and submit a proposed national security memorandum on AI to the President. The memorandum shall address governance of AI as a component of a national security system or for military and intelligence purposes. It shall provide guidance to the Department of Defense, other relevant agencies, and the intelligence community on the continued adoption of AI capabilities to advance the United States national security mission, including through directing specific AI assurance and risk management practices for national security uses of AI that may affect the rights or safety of United States persons and, in appropriate contexts, non-U.S. persons. So, given what I have told you, and that this is the official policy of the executive branch speaking out of two sides of its mouth, I think that it is fair to say that the Executive Order 14086 does not adequately provide an essentially equivalent level of protection. And I promised I'd end on an optimistic note. Some of the new data privacy laws on the state level have data minimization. Some of them have rights to opt out of automated processing. And hopefully Callie and her organization and others can help make this get enacted on a federal level. There's my optimism at the end.
Thank you so much, Margot, for your excellent presentation, which complements very well the research and the kind of findings that we've reached. And you've provided also a very complementary context for understanding some of the dynamics at stake, and also developing some of the points from your very in-depth knowledge on US policy. Very worrying indeed, but also this state-level law is very promising as well, hopefully for a future federal policy on this matter. Now, we have time for Q&A and discussion, and I see already two colleagues with raising their hands, so I guess that there is a microphone. Yes, how do we do? So if you can please introduce yourself and first, and then raise your question. Thank you.
Thank you. Is this on? Can you hear me? Yeah. So I'm Peter Swire. I've written a lot on redress and these topics. And we're going to have a panel at 5:20 this afternoon on very similar topics with two professors criticizing the framework and two professors answering those criticisms. So we can continue the conversation. My specific point right now is to point out that there were two legal instruments issued by the US government. One's the executive order, but not mentioned in the SEPS report or in the panel today is the regulation that's been issued by the Department of Justice. Regulation is sometimes called secondary legislation in the EU. It's a binding legal instrument. It requires people to follow the law. And so the various protections in the DPR, in the Data Protection Review Court, the procedures, the requirement of independence and no conflict of interest, all of these things are written into law in the United States by a regulation. And it would take a repeal of the regulation, which would be public and known to Europe, before those requirements disappear. So when it comes to stability or concerns about not being established in law to have the protections, that seems quite similar to many parts of EU law that could be changed tomorrow. The Parliament, we've seen with the data area a tremendous number of new legal instruments in the last few years that have changed things. So the possibility of change by itself, it's hard to see how that is a reason to consider the legal binding requirement not to apply. The second point is there was very little discussion of standing as an issue for the US government. You can't get to federal courts in the United States under the Constitution, under this Supreme Court, unless the individual can show injury in fact. And when somebody is saying, I might have been surveilled, that hasn't been enough to meet the constitutional minimum for standing in the United States, as Professor Kaminsky said. So we couldn't get to federal court. Nobody has a proposal to get to Article III courts. And instead, the administration created a structure where there's this legal regulation that does have binding effect and does give somebody independence under the law. So maybe you could respond to some of those.
Thank you for your questions. Let's gather another participant. Yeah, just side to you, just in front of you.
That's okay.
Thank you.
Hi, yeah, Michael Veal at UCL. I think some points a question that builds on Peter Swire's question there as well about, in the stickiest challenges, which actors in the US need to be involved? I mean, how many of the problems that, if we were going to conceptually lay them out, would require constitutional change if you want to be very legal pedantry about it? How many and how many would require both sides of Congress to be involved as well? And because neither of those look very likely at the moment, but maybe a bit more anatomy of what those look like and the likelihood of them being real challenges would be useful. Thanks.
And one last participant here before we come back to the panel.
Baron Soka, Tech Freedom. So I have a related question. Maybe Peter's right. Maybe as long as that regulation is in place, that provides adequate removal protection for the board. But what about the Federal Trade Commission? I think it's pretty clear to American lawyers that the Supreme Court is about to overrule the 1935 decision in Humphrey's Executor, which upheld the removal protections in the Federal Trade Commission Act and has thereby been the basis for removal protections in general for federal agencies in the United States. The court has essentially overruled that decision in every other circumstance, for example, with single-member commissions. And I think it's pretty clear that the cake is baked. So if the court does that, and that removal protection provision for federal trade commissioners is void, that means that the president could remove any federal trade commissioner, and so the United States would no longer have an independent a data protection authority equivalent. So that's not something that can be addressed in the US constitutionally. But what bearing do you think that would have in the eyes of the Court of Justice in considering the adequacy determination? So that's my related question. I have a small question for Margot. Margot, you noted the Rite Aid case, and you noted that the Rite Aid case does allege discrimination as a harm. But as I read the case, it alleges two different harms. One is discrimination, and the other is that in general, consumers suffered injury from not being able to make purchases because they were wrongly profiled. And that seems quite distinct from the discrimination harm. So, Margot, do you not read into that a larger attempt by the FTC, which is just a complaint, so it's not litigated. We don't know anything more than that. But at least the FTC seems to be taking a broader approach to the harms that could be associated with the misuse of AI.
Thank you. Excellent questions and comments. First, Francisca, please.
Maybe I'm interested in your question also regarding the FTC, and I wanted to add that I think it's a pity that everyone is focusing on this national security part, because even if we also did it, because it's a lot to talk about, but there's also this commercial part of the agreement. And this would concern the FTC, I would say, problem, as you mentioned it. If, of course, the FTC is not seen as independent, I don't know whether this plays a big role, but the FTC is there to oversee also the commercial part of the agreement. And if there are changes in there, the Commission should also address that. And so far, I didn't see a comprehensive or an analysis of the commercial part of the agreement, and I think this is missing. As well, and this would include, maybe further problems which we did not address in the report because we also focused on national security. But there is this big part on commercial data, which is not yet analyzed, and also, for instance, the commercial part exempts a regulation on AI because the Commission said, well, the companies will analyze data via AI in the EU and they don't send it to the US because they don't do it. I don't know, it's easier to analyze it in the EU, but we don't know whether this is true or not. So I think this analysis on the commercial part and also on the FTC part is still missing. Yeah. And it would probably change something. Thank you.
Margot, you had a question.
Oh, I have so many. Okay, Baron, I'm going to start with you. Thank you for that. I agree. The FTC settlement with Rite Aid is not, or consent decree with Rite Aid is not just about discrimination. There is an attempt to find other harms, but as you put it, for misuses of AI, not for collection or training of AI. And I think that the biggest gap between the US and the EU system, which actually goes to what Callie said about innovation versus privacy, is this idea that everything is fair. Bill McGovern has written about this too. Everything's fair game until there's a harm in the US, versus here, everything has to be brought into some sort of consent or legitimate purpose regime. And that's a really big, as you know, distance between starting points. That lets me also talk just super briefly about the American Privacy Rights Act, because I think this question of training data and privacy is going to potentially be where a lot of the rubber meets the road in transatlantic conflicts. So you see happening at a state level, practically speaking, the Illinois biometrics law is the biggest hurdle to using biometrics information as training data in the US, maybe the only real hurdle. But the California Privacy Protection Agency is also possibly going to put in place in its automated decision-making regulations an ability to opt out of using your personal data as training information. And if the American Privacy Rights Act goes into effect as it's currently written, it would preempt both of those laws. It would contain data minimization, but I don't think would have, you're probably more in the weeds on this than I am, I don't think would have specific provisions that would go towards allowing you to opt out from training data. Okay, now to Peter's point on the DOJ regulation, absolutely makes it stickier. Still a problem. This is all in the executive branch. So the fundamental criticisms of the redress mechanism as not involving courts are still there. This, turning to Michael, goes to the, like, how do we find a solution if in the ideal world we could rewrite everything from scratch and not through an executive order? I just think it's a detente. I'm really sorry that's a disappointing answer, but it's because this involves so many different pieces of the American legal system working in ways that are so different from the EU. So standing being a core element of this, to Michael's point, it's not just the standing question of Clapper versus Amnesty International, which really was about whether national security surveillance existed at all. There is now the standing issue under TransUnion, a subsequent Supreme Court case, where the Roberts Court found there is no standing to get into court to challenge FIPS-based rights. So if you have a right of access or a right of correction, TransUnion, as I understand it, holds you cannot enforce a right of correction or a right of access in a court absent some other form of injury that is equivalent to or analogous to a historic injury like defamation. Okay? It's a really weird test. It is very not European. And so that is in conversation with all these state data privacy laws and the American Privacy Rights Act. Most of the state data privacy laws do not put in place private rights of action. And part of the reason they don't put in place private rights of action is because of a concern that if they put in place private rights of action, courts would find them to be unenforceable. Okay? So this is a lot of lobbying. So there's also a lot of lobbying to prevent them from putting in place private rights of action. So these are some of the things that they're bigger than a transatlantic dialogue. They have to do with the current Supreme Court and its deregulatory elements and its hatred of class action litigation. They have to do with bigger picture, like the lobbying dynamics of small and medium-sized enterprises in state lawmaking. So I think I'll end with that there.
Thank you.
I don't know if Callie wanted to contribute to that too. I think you probably should.
Yeah, I'm so happy to. Yeah, those are all really great questions. First, to Peter's point, you're absolutely right. And frankly, a lot of the focus on the stability issues of the executive order are, even if the regulation didn't exist, that's not the biggest problem with the structure. So the fact that we keep bringing it up probably is a little tired, and we should probably relax that and focus on the bigger issues. As Margot said, the issue I have with the regulation is that it enshrines a structure that I think just fundamentally doesn't function well. And it does it with more stability, but it's still a structure that doesn't function very well. There are the issues of independence that follow with that. And frankly, I think it's really important that you brought up the standing issue. That's a huge problem that we're running into. And it's a huge problem in general when it comes to surveillance challenges, because how do you prove something that by its nature is kept from you? It's very hard to establish that you're being harmed by a thing that if they're doing it correctly or doing it well, you won't know is happening. That's a challenge we run into a lot at Epic. We do some litigation work, we do some investigation work, as well as our policy and research work. And I can tell you from sitting in on those litigation meetings and trying very hard to come up with cases on it, it is so challenging to get anywhere near a standing level where you can say, we know this is happening. We all can see this is happening. We've got at least bits of evidence that this program exists. We've got a lot of fairly circumstantial evidence that this person we're trying to represent almost certainly is being tracked by this program, but we cannot find something factual to back that up. We cannot find the evidence to back that up. That is a constant challenge we run into, and yeah, standing is a serious problem there. To Michael's point, I agree with Margot that at some level, it's kind of a fundamental issue of how the American legal structure has let itself evolve into this very complex, very sprawling structure where you would have to address so many multiple parts of that structure to reestablish something that gets close to an adequacy decision. I'm not saying it's impossible. Like, that's part of the work that Epic does. That's what we're pushing for. It is just a very Sisyphean piece of work in a lot of cases. So I do think it's possible. I do think that there is a lot more appetite for change. There's a lot more general awareness of privacy and surveillance issues as a whole. There's a lot of pushback in the US at the state level, at the local level, from civil society groups, from people within government offices, like the Attorney General in Colorado, who used to be my law professor, the dean of my law school, actually. He's very, very active in tech and privacy work, and he has been working really hard at putting together a good state privacy law and trying to push for coalition work, but he's one attorney general, and that's one state, and that's not the same as a federal privacy and equivalence level. So we're working on it, but I do think it's a very long process that would take a level of acknowledging the weaknesses and failures in the US system when it comes to privacy and surveillance that I just don't know that we're at yet. And there's one other US issue that I have to raise just because it's very top of mind and we run into it a lot. The lobbying efforts by big tech companies are massive and in many cases are actually detrimental to a lot of other tech companies. I used to do compliance work for companies on privacy issues. I wrote their privacy policies and I helped them with when the data transfers when Privacy Shield was invalidated. And it's incredibly difficult. And the way that big tech lobbies for certain policies is actually detrimental to most other companies because they then don't have the stability of like a clear way to do data transfers in the wake of a big decision like that. The big tech companies are pushing for such an absence of accountability in this space that they leave it with no regulation in a lot of cases, which leads to a lot of uncertainty for smaller companies and a lot of cost to them. So it's really detrimental to everyone but big tech, and if I may be really overly frank here, the politicians and lobbyists that are getting funded by big tech. So the big tech push is something that we're also facing really serious issues with when it comes to regulation in the US. They are able to get into that legislative discussion when regulations are proposed and manipulate the language and have a lot of influence in the language at a state level, a local level, and a federal level. And being able to, as civil society groups who are much lower funded, push back against that is another aspect of that challenge in the US. And then finally, to Baron's point, I am very nervous about the Supreme Court case and the FTC's power. I think it's very clear what direction we're heading. And I think it's a serious problem for the EU when we're looking at adequacy decisions and we're looking at establishing some level of protection that the US, the very few agencies we have that are doing consumer protection and that are focusing on privacy in addition to their enormous pile of other work they do on top of privacy. Just for very quick context, the Federal Trade Commission does not just do like privacy data protection stuff. They are very, very broad consumer protection. The last hearing covered some tech issues, but also like what kind of labeling you have to have on sodas in certain contexts for safety on sugar levels. Like it's unbelievably broad what they have to cover with very limited resources. And I think that even with those limited resources, we may be losing that agency that has been more focused on protections is really concerning. As far as I can see in the landscape, there are other agencies that have very specific areas they look at for privacy protections, but they do not cover anything nearly as broad as the Commission. And if the Commission loses some of its power, I think we're in really serious trouble when it comes to consumer protection in the US.
Excellent comments as well. Thank you so much for sharing all this. We still have a few minutes, so if anybody else has a final question or comment, you're most welcome to join, please.
It's Eduardo Ostrom from Hogan Lovells, and I've got a very quick question for all four of you, or quick answer, please. Based on your analysis, what would be the percentage of the chances of the European Court of Justice deciding the same fate for the data privacy framework as for the Privacy Shield and previously the Safe Harbour in a hypothetical Strength 3 decision? A percentage, a number will be sufficient.
And perhaps some substance, not just number, but some substance, perhaps.
The analysis was beautiful. I just need a percentage.
Well, you may interpret this question and answer as you consider best, because this will be your last statement, and we close the panel. Perhaps I will start with Georgia this time.
Thank you.
Because you also raised these points.
Yeah,
so
I
please.
was quite explicit with figures, so that's probably something wrong that I've done to challenge or probably to trigger the question. I wouldn't like to give really a specific percentage. I can say that if we have half of the chances to challenge again this decision, it's less than 50%, I would say. And why that? Because in order to bring the case for the substantial part of it before the court, you need first of all to justify that the person introducing the complaint, let's say, or the case has also an interest for doing so, so that there is an obvious harm basically against the person. And sometimes it's, you know, probably that already there was at least one case where there was an attempt to challenge already the DPF, and it didn't go on because of the fact that it was very difficult to substantiate, to justify the harm, the person's interest to challenge basically this. So to me, it's really difficult. It will be hard this time, and I want also to again reaffirm the interest and even the demand of the private and public sector, so on the client side, to go ahead a bit. So already we live in a very difficult geopolitical situation here. We talk about a quarrel. We gave the title of a quarrel EU-US. I believe that we have, for the moment, a lot of quarrels to deal with in order to add on a new one. There is some positive, I believe, to me at least, there is a positive sign that there is a decision there that tries to somehow justify the 80% of transactions that are done between the EU-US, so the industry in the EU, so the flows of data from the EU to the US amount to 80%, and 70% of those come from small and medium-sized enterprises. And why that? Because we use service providers as well, which, as all of you know, are based in the US, or at least quite a lot of their services is done and managed in the US. So for this reason, and only I would say that, yes, it is good to try to keep the percentage low, and it is in our interest, in the interest of all economic operators, I think.
Thank you. I mean, that bell, the bell has a huge symbolic power. It's impressive, by the way, it's huge. Would you like, Ali, also final statement, and Margot, final statement?
Sure. For percentage-wise, I would say I come down on about a 70% likelihood it'll be overturned. The reason it's not higher is because I think there's a huge government interest and a huge business interest in it standing. And I think a lot of really, really thoughtful work went into this. They clearly tried very hard to make a good structure, and I think we'll fight very hard to defend it. Both the EU and US representatives, I think, were working very hard to come up with something feasible. The reason I still think it's more likely to be overturned is I just don't see how it even addressed the problems that were raised in Schrems 2. I don't think it even addressed those issues, much less any new issues that may get raised. So I think it's at risk, unfortunately.
I'm not going to give you a number. I'm going to give you a term. Ping pong. It's just going to go back and forth. The court in Schrems 2 set a standard that the U.S., I think, can't meet. And so that's the interesting question. Like, is this going to go on forever, that it's going to go back and forth? And, you know, I think absent any real interest, well, here's a counterfactual situation that I told you I would try to end by being optimistic. Let's say the next time 702 goes up for reauthorization, there's enough, we were almost there, there's enough political will to try to restrict it in some ways on the US side, right? Let's say that happens. And let's say that it involves some increased notification to people who had been subject to surveillance. And let's say that people who had actually been subject to national security surveillance were able to trace harms to some actual economic harm and could then get cases into court. I think then you start seeing a situation where, and some norms shift in the United States. We enact federal data privacy law. People start understanding data privacy harms as harms and not just economic harms as harms. Then I think in that counterfactual world, we maybe get to a place where this question about rule of law and national security surveillance becomes a place where the two economic entities can meet more favorably.
So it's not impossible, there's hope. Francisco?
Yeah, very, very briefly, because I know you want to leave. I think there are good reasons to strike it down, actually, but I also think there's a certain fatigue over the last years. There's this political aspect which has changed compared to the first two judgments. So I think it's 50% only, because I was involved in the first two cases, so I know a bit the background, and now I think, this fatigue and this changing landscape has its effects also at the Court of Justice. Sorry, not that optimistic.
And yes, and to close the panel about the fatigue, I mean, it's a constant, daily struggle, democracy and rule of law.
Yeah.
So it's not to be taken for granted. So thank you so much to all the speakers and to all of you for your presence. We are very grateful, and have a wonderful continuation of the conference. Thank you.